Good morning, good afternoon, good evening, class. We are about to end our coverage for sales and leases, and we are on our last topic, the contract of lease. As a constant reminder, consider this video recording as a supplement to your readings. No, do not heavily rely on this. Instead, confirm what you know with our lectures, and hopefully this could help you in navigating your sales and lease contract. So let us begin with the definition of a lease. What is a lease? Okay, now lease is a contract whereby a person for a consideration gives to another the possession, use, and enjoyment of a property for a period which may be fixed or not fixed. Now, take note, class, that from this definition, we can expand the different elements of a valid lease contract. So, first and foremost, it is a contract for consideration. So, uh, a lease is always a contract with a cost. So, if you let another person borrow or use or enjoy your property without any consideration, then that ceases to be a lease. Instead, it could either be a commoditum, okay, for use of the property gratuitously. If it's use of both the property and the enjoyment of the fruit of the property, then it could be a contract of usufructuary. And then if it's a consumable thing, again, without any consideration, and it's a contract of mutuo. So another thing is that there is no transfer of ownership in the lease contract. No? So you are merely allowing another to use or enjoy a property for a period. No? So how long would that period be? So uh, you adhere first and foremost to the stipulations contained in the contract. Or if the period is not fixed, then we refer to those provisions, which I will later on discuss, which provides, no, the law provides to fix the period, no, if the period is not fixed in the contract of lease. Now, again and again, the lease period depends on the agreement of the parties, but in no case shall exceed 99 years. Okay? But of course, it is merely, these parties can easily skirt on into this. For example, if the 99-year period is terminated, then they could again enter into another 99-year period contract of lease. So they can renew a contract of lease as long as they want. No? So they are at liberty or freedom to enter into another lease contract. Now, it's a different story if it is a foreigner, because we all know that foreigners will not be allowed to acquire properties in the Philippines, except siguro if it's through an inheritance. But they're allowed to lease properties in the Philippines for a maximum period of 25 years, renewable for another 25. Now, it's a different period if it's for an investment purpose. No? So the law allows up to a maximum of 50 years, renewable for another 25 years. So that's under RA 7652 or the Foreign Investment Act. Now, if you may have recalled in your obligations and contract, you know that a purely potestative condition is void. Okay? The terms of the contract cannot be left to the will of one of the contracting parties alone. In the same manner that a lease contract, providing that the lessee can stay in the premises for as long as he can pay the rentals, and its increases are not permissible because it is a purely potestative condition. No? It leaves the effectivity and enjoyment of the leasehold rights to the sole and exclusive will of the lessee. So that's not allowed. That's very clear. Now, as I mentioned earlier, what happens? So how do the law fixes the period when the parties fail to give a definitive ending to the contract? No, for rural lands, okay, so as to give the time for the lessee to harvest its yield, no, in 1 year. Now, if it's a one-time yield or one-time harvest, so at the end of the harvest, even if it extend to, let's say, 2 years or more. Okay. Now, for urban lands, you have to refer to the nature of payment. So if you pay on a day-to-day basis, weekly basis, monthly basis, or annual basis, then that's essentially the period of your lease contract. So for example, you paid 5,000 for a 1 week stay in a premises. The presumption is that your lease contract is only for 1 week. Okay. So again, that is a disputable presumption and it could be overridden by stipulation of the parties. Okay. Now, as an exception to the potestative condition ruling in a lease contract, we have here the case of Espejo Realty versus the Court of Appeals. No? So when the wordings of the lease contract is unequivocal, so in the lease contract, the parties agreed that the lease period shall continue for an indefinite period, provided the lessee is up to date in the payment of his monthly rental. So the Supreme Court said there is nothing wrong with that provision. No? So it is not a potestative contract because it is a contract subject to a resolutory condition, which is the non-fulfillment of the payment. Okay. Now, the condition imposed in order that the contract shall remain effective is that the lessee is up to date to his monthly payment. So the moment that he does not fulfill the monthly payment, then that's a resolutory condition which will terminate the contract. No. So in this case, it is undisputed that the lessees religiously pay the rent at the increasing rate of 20% annually as stipulated in the contract. So there is no reason actually for the lessor to file an ejectment case against the lessee. Okay, so this is I think with respect to an apartment unit rented by the corporation for its executives. No? So the lessor filed an ejectment case against the lessee, and then in turn, the lessees tendered payment through consignation in the courts. The Supreme Court said that the consignation of payment is a sufficient fulfillment of the condition in the contract. So there was valid payment made by the lessees, therefore the contract is still subsisting. Okay. The original terms and conditions agreed upon when the petitioner unilaterally increased the rental payment to more than 20% or 3,500 a month was fulfilled by the lessees through consignation of the payment. So in this case, the Supreme Court said that the lessees are yet to break the resolutory condition. Therefore, the lease contract continues to be valid and subsisting. So what are the subject matter in a contract of lease? So it could be things, service, or work. So things, it's either real or personal property. That's very self-explanatory. Service or work, so if you hire a designer or an architect or what do you call this, a painter to commission for an output, so there is no employer-employee relationship. So there is a contract of lease or contract, more properly known as a contract for a piece of work. So you cannot own the talent by the architect or by the designer, but you can use them for a time being, for a period, and for a certain project. So that is a lease of contract of service. Okay. Consumable goods cannot be subject matter of lease. So except if it's merely for exhibition. Okay. So because if it's consumable, then there is nothing to return. Then it ceases to be a lease. Okay. Kailangan ba ang lessor is the owner of the thing at the time of the lease? No, because there is no transfer of ownership per se. What the lessor will transfer is only the enjoyment or use of the property. In fact, the lessee can sublease the premise the lease property. Okay, so you call that a sublease agreement. So there is nothing wrong there. It is not a um, limiting factor. The mere fact that the lessor or the sublessor is not the owner of the property. Okay, rental. This is the consideration or cost of the contract of lease. So the right to fix the rent belongs to the lessor. However, if it's exorbitant, the court may intervene and fix it, no? Reasonable rent. Now, the right to increase rent is not absolute on the part of the lessor. So it needs consent of the lessee. So again, no, under the mutuality of the contract, the parties are free to stipulate whatever they want as long as it is within the bounds of the law. So there is nothing wrong with that. Okay, now remember class when I discussed about those persons that are disqualified to enter into a contract of sale, those same persons are also disqualified. No? Same persons are disqualified to enter into a contract of lease. So, husbands and wives, guardian and ward, principal and its agent, public officials, judges with respect to the subject matter under litigation. So, those are also applicable in the contract of lease. Okay, now annotation or recording of a contract of lease in the registry of deeds is not a requirement. But if you want the third person or if you want it to be of public knowledge, then you can annotate it as a protection on the part of the lessee. Now, if the lessee cannot do it on its own, he must give these following persons special power of authority. So the husband with respect to the wife's paraphernalia, real estate, the father or guardian as to the property of the minor or ward, and the manager. They must, for them to be to act in behalf of the principal, they must be given a special power to do that. Is recording a requirement? No, but it is an added protection. So it's the lessee is given that option. And Article 1648 specifically deals with this. No? So every lease of real estate, no? So take note, real estate may be recorded in the registry of property. Unless a lease is recorded, it shall not be binding upon third person. So take note that a lease contract is an encumbrance on the property. So if the buyer is aware that there is an existing lease in the property that he is buying, then he has to respect the stipulations contained in the lease contract. So because it is an encumbrance on his property. But if he does not know the existence of the lease, such that the lease was not registered in the registry of deeds and it was not annotated at the back of the property, then he is not bound by the lease contract. Exception is in the case of Lao versus Lao. So of course, if the purchaser can be proven that he has actual knowledge of the existence of the lease prior to him buying the property, so that knowledge is equivalent to registration. Therefore, he is bound by the lease. Okay, now, if the lease is terminated, the lessee shall file an affidavit of termination of the lease and file it before the registry of deeds so that the encumbrance or annotation may be cancelled. Okay. Now, can lessee assign his rights to another person? No. So the general rule, you have to differentiate it with sublease, no? Because assignment gives out more rights to the transferee. So therefore, it also follows a stricter rule. Take note that in assignment, there is, in effect, an novation of the contract, the replacement by the lessee in the person of the assignee. So there's essentially the extinguishment of the contract by novation. So therefore, before the lessee may assign it to somebody else, his right, it must be consented by the lessor. So there's a stricter rule. In opposed to what do you call this, to sublease agreement, generally, the lessee is allowed to enter into a sublease agreement unless there is a prohibition by the lessor. So that's the rule on that. So that's Article 1650. So as long as there is no express prohibition, the lessee may sublet the thing lease in whole or in part. Now, there was a clarification made in the Maliarte case because in this case kasi, they were taking in of boarders. So the lessee is renting the property. There is an excess area where he allows boarders, no, to come in with him. So in this case, the lessee is not actually dispossessed of the property. He is still actually occupying the property. So the Supreme Court said that there is no violation, no, on the prohibition against subleasing because the taking in of boarders is not embraced within the prohibition against subleasing. No? So it is not equivalent to that. The lessee, by accepting boarders and assigning rooms or bed spaces for them in the leased premises, does not relinquish or surrender his lease to them. He did not cease to become the actual occupant thereof. Okay, so essentially, there is no prohibition. There is no violation of the prohibition against subleasing. Okay. As a general rule, there is no juridical relationship between the lessor and the sublessee. The sublessee is directly liable to the sublessor. So, unlike an assignment wherein the assignee takes over, no, the rights of the lessee, in a sublease contract, there are essentially two contracts. The contract of lease, which is the main contract, and the second byproduct contract, which is the sublease agreement. So there is no juridical relationship between the original lessor and the sublessee. Okay? Only in two cases, no, where the sublessee will be liable to the lessor. Okay? When it pertains to the acts which refers to the use and preservation of the thing lease. So as I said, the sublease agreement is a byproduct of the main lease agreement. So the sublease agreement cannot expand beyond what is stipulated in the lease agreement. Okay, so if it pertains to those use and preservation of the thing lease, then the sublessee will be bound or liable to the lessor. For example, in the lease agreement, there was a stipulation which prohibits the entrance of any fire hazards. Okay. However, in the sublease agreement, si sublessee pala is a trader of this paints, no? So, 'di ba yung mga paints, ano yan, fire hazard yan. So, in that case, any damage to the property of the lessor, the sublessee will be liable to the lessor because there pertains to the use and preservation of the things. Okay, so in fact, the lessor could file an action directa against the sublessee. So it is an action which the lessor may bring against the sublessee who misuses the subleased property. Okay. Second instance where the lessor and the sublessee may have an interaction is that the sublessee is subsidiarily liable to the lessor for any rent due from the lessee, but the amount should not extend to what they have agreed on with the sublessor. So for example, the original lease, the payment of rental is at 10,000. Okay, but the sublessee and the sublessor entered into a stipulation of only 8,000. So the sublessee is not required to pay more than 8,000. Okay, and his liability is only subsidiary. So it only arises upon failure of the original lessee to pay. Okay. So when does delay occurs? At the time of extrajudicial demand by the lessor. So any payments in advance made by the sublessee is not deemed to have been made so far as the lessor's claim is concerned. So only if ever the sublessee will pay advance rental, the lessor could not claim that in his favor, okay, because these are not due and demandable. Okay, so let us go now to the obligations of the lessor. So a lessor is obligated first and foremost to deliver the thing, the leased premises, in a condition such as to render it fit for the use intended. So if it's for residential purposes, of course, it must have bedrooms, it must have kitchen areas, etc., etc. If it is an office space, and it must have provision for parking, it must have spaces for what you call this, for office and whatnot, no? So it must have our air conditioning provisions, etc., etc. Okay. Now, what if the lessor misrepresented to the lessee? So, hindi pala masyadong quality yung property as represented by the lessor. So, may mga kulang. So, dalawa yung option ni lessee, no? He could either rescind the contract to cancel, not continue on with the contract, or he could have action for quantum minores. No? So, reduce the rent based on the actual status of the property. So, those are the things that the lessee may pursue. Okay? Second is to make necessary repairs. Of course, kung may sira or kung may leakage, or kung may sira sa wires, doorknobs, tiles, those usual repairs, these are all ordinary repairs, all on account of the lessor. Okay? Because he must maintain the leased property in its suitable use. Okay? Third, and I think this is a controversial provision, take note of this, is to maintain the lessee in the peaceful and adequate enjoyment of the lease for the entire duration of the contract. What do you mean by peaceful and adequate enjoyment? No? So what if my trespasser pumunta sa property, leased premises? Is the lessor obligated to the lessee? No. Okay, so you have to be very clear on that. What this means is that legal, peaceful, and adequate enjoyment. If the law said that if there is a trespasser, the lessee himself has the personality or legal standing to file a case against the trespasser, because he is given actual use or enjoyment of the property. What is meant by the law? If there is somebody who claims to be the owner of the property, then the lessor is obligated to the lessee because he has warranty against eviction. So pinapaalis nung supposedly owner of the property si lessee. So the lessor should be the one to face the third party, no, because he has warranty of peaceful and adequate enjoyment. So you should distinguish those two. Okay, so we would further discuss on the third obligation later on. May mga clarification yan later on. Okay, another obligation of the lessor cannot alter the form of the thing leased in such a way as to impair the use to which the thing is devoted under the terms of the lease. So for example, I lease a commercial space. No? So many commercial spaces require that the area has to be seen. No? There's signages, there's to be an ample way to enter inside the leased unit. Now, itong si lessor, nagpatayo ba naman ng another building in front of the leased building? No? So, this is not allowed because it impeded the visual of the commercial space. No? So, that's where Article 1661 comes in. Okay? Now, what if the lessor intends to sell the property? No? The lessee, if stipulated, has the right of first refusal. So the lessor must offer first, for a reasonable price to the lessee, the sale of the property. So if the lessee refuses, then he can offer it to other persons. Okay, interested. Now, what if the lessee makes useful improvements? So this is not the same with necessary repairs, because useful improvements are those that adds to the value of the property. So, especially in long-term lease, no, 30 years, 40 years, 50 years, usually may mga added improvements ang ginagawa ang lessee. Like for example, nagdagdag ng floor, okay, or naglagay ng elevator, naglagay ng parking area. So these are useful improvements which will further the use for the property. So according to 1678, one half of the value of the improvements at that time must be reimbursed by the lessor. Why? Because on a matter of equity, when the lease terminates, the lessee will leave all of these useful improvements, which the lessor will continue to enjoy, or a subsequent lessee will continue to enjoy. And perhaps the rental of the subsequent rental will be increased because of this useful improvement. So it's just the matter of equity that the lessor shall pay one half of the value of the improvements. Now, who has the choice to retain the same? Of course, the lessor is given the choice. So if the lessor chooses not to pay the one half, then the lessee may remove the improvements. No? So even if the principal thing may suffer damage, um, kasalanan ni lessor, no? He was given the chance uh, to reimburse for the improvements. Now, how about ornamental expenses? These are removable objects such as TV or di kaya air cons, no? So plants. Okay, so the lessee shall not be entitled to any reimbursement, but he may remove the ornamental objects, no? Provided walang damage to the principal thing. So I just remember in front of our house there is a vacant lot. I use it as a garden area. So because I know that at any time I could be evicted there because na nga, planter in bad faith because I don't own the property. Nilagay ko talaga sa pots lahat. Even if sometimes I am tempted to have it grown directly to the soil because plants, grow better directly. So anyways, that's it. You could also relate it to the provisions of property, diba? Builders or planters in bad faith will have to um, we have to bear for the damages or the consequences of his action. That's why Article 1678, ang pambungad niya is that the lessee must be in good faith. Okay? Because if he is in bad faith, then the lessor in turn will not be held liable for the one half. Okay. So what will happen if the lessor needs to make some urgent repairs on the same lease? Like for example, bumagyo. Okay. So natanggal yung buong front ng bahay. So of course, even if it's inconvenient on the part of the lessee, he has to tolerate the work. However, if the repair lasts for more than 40 days, there should be a reduction in the rent. Okay. And if like a portion of the property is to be repaired, which deprives the lessee of the use thereof, there also must be an equitable reduction of the rent based on the unused portion. Okay. Now, if in the opinion of the lessee, the dwelling becomes uninhabitable, so he always can choose to rescind or cancel the contract. Okay. So in all of this, dalawa lang yan eh. It's either recession of the contract o di kaya you ask for damages and then continue with the contract. Now, those are the available remedies for the aggrieved party. Okay, so ito yung sinabi ko kanina, there are two kinds of trespass in lease. Yung trespass in fact, provided for by Article 1664, the lessor is not obliged to answer for a mere act of trespass which a third person may cause on the use of the thing leased. The lessee shall have a direct action against the intruder. So on his own accord, the lessee, being the possessor of the property, has the personality to file the proper case against the intruder. So there is no need for the lessor to intervene. That is confirmed in the case of Bercero versus Capital Development. It says that the duty to maintain the lessee in the peaceful enjoyment of the lease is a warranty that lessee shall not be disturbed in his legal and not physical possession. So only in trespass in law where the lessor may be obligated to intervene, no? But trespass in fact, the lessee can do it on his own accord. Okay, so in trespass in law, the lessor shall be held liable to the lessee, and he may maintain an action to recover title or to establish better possession. So it's either action reivindicatoria or action publicana. So let us go to the obligations of the lessee. So first and foremost, of course, you have to pay the rent according to the terms. Okay? Can the lessor eject the lessee for non-payment of rent? Yes. No, so there is a judicial ejectment. So we will discuss further on that later. Number two, to use the thing lease as the diligent father of a family. Okay. A normal wear and tear is allowed. However, any damage to the property which is caused by the lessee or a member of his household, the lessee shall be liable. Another thing is to pay expenses for the deed of lease, no? So notarial services, no? The lessee is the one to pay for that. To tolerate urgent repairs as discussed earlier. Okay, another obligation of the lessee is to bring to the knowledge of the lessor, no? ASAP, every usurpation or untoward act which any third person may have committed or may be openly preparing to carry out upon the thing. So if there is a legal trespass, the lessee is obliged to inform the lessor immediately. Okay. Another one, return the thing leased upon the termination, okay, as he received it. That's Article 1665. So again, no, the remedies available to the aggrieved party may be rescission of the contract or indemnification for damages, no, or only damages and allowing the contract to remain in force, no. So either way, for example, if the lessee has incurred expenses, which should be on account of the lessor, so he could demand damages by uh, actual damages by actually reducing the amount of rent that he has to pay. Okay. Now, another important concept is found in Article 1670. So what if there is already a determination of the lease pero wala ka pang notice to vacate? Okay? Hindi ka pa pinapaalis ni landlord. No? So the law said that there is an implied new lease, tacita reconduction. So within 15 days, you're still enjoying the thing despite the termination of the contract. All of the stipulation in the original lease shall be revived except for the stipulation on the period. Because, like for example, the original period is for 3 years, that will no longer suffice. No? What will apply is the time established in Article 1682 and 1687, yung month-to-month, day-to-day, etc., etc. So those are what will cover the implied new lease. Now, as I said, the lessor may judicially eject the lessee for any of the following. Okay, so expiration of the period, of course, lack of payment, violation of any of the conditions agreed upon in the contract. Okay, when the lessee devotes the thing lease to any use or service not stipulated. So kung kunwari the lease premises is for internet, no? Internet cafe, but the lessee actually use it as a porn site, o di kaya he made it as a drug den, o di kaya ginawa niyang parlor, no? Even if it's not an illegal activity, there is already the right to eject the lessee. Now, the route is usually judicial, but there is this extrajudicial repossession clause. No? So without going to court, the parties may enter into part of the stipulation of the contract wherein um, the lessor is allowed to repossess the property. Okay, so in Veray versus Intermediate Appellate Court, the Supreme Court says that if there is a stipulation in the lease contract which authorizes repossession of the premises without a court action, such stipulation is valid. It is in the nature of a resolutory condition, for upon the exercise of the lessor of his right to take possession of the leased property when the contract is deemed terminated. Now, usually, also in the same decision, the Supreme Court said it is proper for the lessor to use reasonable force to recover the property by padlocking the leased premises. So he is allowed. So pwede niyang ipadlock yung leased premises if it is contained in the contract. Otherwise, yung route niya is judicial, no? Judicial case for ejectment. So, wag na kayong magugulat, no? If yung landlord nyo, pinadlock yung, ano nyo, yung uh, rented unit nyo for non-payment or for any violation contained in the contract, provided that such extrajudicial repossession is included in your lease contract. So pinirmahan mo you agreed upon it. So it's okay. No, otherwise, kung walang ganyan, usually you will file a case for ejectment. No? So under Rule 70. So it's either forcible entry or unlawful detainer. But the more proper pleading is for unlawful detainer, which is made 1 year from the time of your demand to vacate. So you have to notify the lessee of a notice to vacate or demand to vacate, and the 1 year prescriptive period shall run from the notice. Ma'am, paano kung sumobra ng 1 year? So doon ka na sa usual, sa natural, sa ordinary proceeding of recovery of possession. Okay? Again, huwag ka magpa-file ng forcible entry. Because first and foremost, yung prescriptive period mo is dangerous. Because in forcible entry, the prescriptive period is reckoned 1 year from the time of entry. Okay? And in forcible entry, there is no previous legal right to possess the property. In unlawful detainer, the possession is previously lawful, but it has now become unlawful because of the termination of the contract of lease. Okay. Okay, so I think that's about it for lease contract. I hope I will see you in the next video for our Maseda in Recto Law. Okay, so thank you very much, class, for listening up to this point, and I see you soon. Thank you.